Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya and today we are going to discuss a very important legislation that is used to protect our integrity and sovereignty. The title of our today's discussion is the Unlawful Activities Prevention Act or the UAPA. In this discussion, we are going to study about what is UAPA. We'll also trace its origin and we are also going to analyze its scope and expansion. We are also going to study about some of its key provisions. We are also going to study the UAPA tribunal, and in the end, we are going to see a practice question for your prelims examination and a practice question for your mains examination. So now let us proceed to understand the background of our today's discussion. So if I talk about the background of our today's discussion, you might have heard in the news recently that the founders and editors of this news portal named as NewsClick have been arrested and detained under the UAPA Act. So what is this UAPA Act? What was the purpose for which it was enacted? How it came in to be enacted? We are going to study all of this in our further slides. So now let us understand and move forward to see what is UAPA. So if I talk about this Unlawful Activities Prevention Act, this act was very important and it came at a time when India was already facing a lot of insurgencies. India has had its own fair share of terrorist attacks. The terrorist attacks of 2008 on Bombay being one of them. So India realized that, okay, the normal criminal laws are not, useful and powerful to deal with certain criminal activities, and that is why a stringent legislation was required, and hence came the UAPA. It was enacted in the year 1967 and it gives the central government sweeping powers to declare and designate organizations as terrorist organizations and also prescribes the penalties for taking part in the activities of such organizations. And if these organizations are declared to be terrorist organizations, they are declared under section 3 of this UAPA. Now moving further, let us analyze the origin, or let us study about how this UAPA came to be legislated in India. So if I talk about the origin of this UAPA, 1960s was the time when India was facing at the peak of the insurgencies. The government had to deal with a lot of insurgencies. And what happened was, in March 1967, a peasant uprising in Naxalbari imparted a sense of urgency. And that is why the government decided that it needs to do something about handling these situations, because our normal penal law such as the IPC and the CRPC were not capable enough to deal with terrorist activities and these kinds of insurgencies. So the president enacted the Unlawful Activities Prevention Ordinance, and this ordinance was promulgated with an aim to stop these terrorist activities or insurgencies and to protect the sovereignty and integrity of India. This, as we all know, for an ordinance to become a law, it has to be presented within 6 months to the parliament. But when this ordinance was presented in the parliament, it was met with a furor about the stringent provisions it had. So there was a high debate in the parliament regarding the strictness of these provisions. So the parliament completely dropped this ordinance and passed the UAPA Act of 1967. UAPA Act of 1967. And this UAPA Act of 1967 was very different from the ordinance because of the debate that was going on in the parliament about its stringent provisions. Now let us understand scope and expansion of this Unlawful Activities Prevention Act. So the act assigns absolute power to the central government by way of which the centre deems an activity as unlawful, then it may by way of an official gadget declare it so. So as I was discussing this before also, this gives a sweeping power to the central government to prevent any kind of unlawful or terrorist activity. In fact, most of the terrorist organizations are also banned under this act. Under UAPA, both Indian and foreign nationals can be charged. This is a unique provision of UAPA that it applies not only on the Indian citizens, but also on the foreign citizens. If the foreign nationals are trying to commit any offense which has an impact on India, or they are trying to commit an offense which promotes enmity, promotes terrorism in India. It will be applicable to the offenders in the same manner if the crime committed on a foreign land outside India. So what does this mean? For example, there is this person A who is sitting in USA, or for that matter any other country, and he plans something in relation with India and in collaboration with this person B. Then this person A, even though he is sitting in the USA, he will be liable under this act if it is proved that he was trying to promote terrorist activity in India while sitting in the USA. So India will ask the USA to permission to extradite this A person, and then he will be prosecuted under the UAPA Act. And this is a very important extraterritorial operation of this act. And if I talk about the expansion of its scope was highly expanded after the 2004 amendment to include the suggestions by the United Nations Security Council. The 2004 amendment added terrorist act to the list of offenses to ban organizations for terrorist activities, under which 34 outfits were banned, and the latest being the PFI. This organization was also banned under the UAPA Act, and 2004 amendment is one of the important amendments which has enlarged the scope of this UAPA Act. The Unlawful Activities Prevention Amendment Act of 2019 designates individuals as terrorists. So the 2019 Amendment Act has even granted or even widened the scope and powers given to the central government. Now an individual can also be designated as a terrorist under the UAPA Act, and we have seen various examples of individual being declared as terrorist under the UAPA Act. So if I talk about the key provisions of this act, you will ask me that, ma'am, some of the key provisions are in news, and what are these key provisions? So the key provisions of UAPA Act are section 15, which defines terrorist act. Kindly pay attention to this provision, that section 15 defines what is known as a terrorist act, and it includes use of bombs, dynamites, etc. to cause terrorist activities in India. Then it also involves causing of death, or loss of public property. Loss of public property. Then it also involves economic offenses. For example, economic offenses includes, for example, there is this group of persons A, B, C, D, and they are involved in counterfeiting and smuggling Indian currency. Then they will also be prosecuted under the section 15 of UAPA Act, as it includes within its purview economic offenses as well. So whatever the offenses are there which harms the security, sovereignty and integrity of India, they will be declared as terrorist activities. Then this is an offense that describes violent acts that are serious in nature. The provision reads as whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, economic security included, or sovereignty of India, or with intent to strike terror or likely to strike terror in the people or any section of the people in India or in any foreign country, they will be punished under section 15 of the UAPA Act. And this section 15 revolves around defining what are terrorist act, and as I have explained, it includes all of these points. So the punishment for these terrorist act is given under section 16 of the Unlawful Activities Prevention Act. So section 16 prescribes the punishment for terrorist activities, and as I have discussed this before also, the highest punishment under this act is life imprisonment or even death in certain cases. So this makes the provisions almost very stringent in nature, because you see the highest amount of punishment that can be given are also stringent, that either it is life imprisonment or it is death. And that is why UAPA is often criticized that it is very stringent in nature. Then there is one important provisions which is in news and which is highly debated as well, and that is the provision of bail under section 43 clause D subclause 5 of the Act. Bail cannot be granted to a suspect if the court is of the opinion that there are reasonable grounds to believe that the charges are prima facie true. So let me explain this in very simple language. For example, whenever you go to the court and ask, you have been arrested under some provision, you go to the court and ask for the bail. So the court will look at the case and it will presume your innocence. It will not presume that the accused is prima facie guilty. No, there is a presumption of innocence in favor of the accused in normal criminal laws. But this is not the case in the case of UAPA. In the case of UAPA, the court will presume that the accused is guilty. Accused has to prove that he is not guilty. So that is why it is said that UAPA is completely opposite of the rule that bail is the exception. Sorry, bail is the rule. Bail is the rule and jail is the exception. This is a general rule of criminal law, but this does not apply on the UAPA. In UAPA, it is completely opposite, that jail is the rule and bail is the exception. And the provisions are so stringent that it is almost impossible to get bail. Why? Because the UAPA Act does not authorize the court to go through the prima facie evidence. If the court believes that prima facie, like on the face of it, it founds that the state has a strong case and the person is guilty, then the court is going to ask the accused to prove that he is not guilty. The court is not going to ask the state, and that is why it makes the provisions so stringent in nature that even bail cannot be granted like a regular bail under UAPA. The test for denying bail under the UAPA is that the court must be satisfied that a prima facie case exists against the accused. So this is what I was explaining you before also. The court after going through a plenary reading, like it will not go into the depth of the evidence, and then the court will decide that whether there exists a prima facie case against the accused, and if the court is satisfied, then the court is not going to grant you a bail under UAPA. There is this important judgment as well. In 2019, the SA defined prima facie narrowly to mean that the court must not analyze evidence or circumstances, but look at the totality of the case presented by the state. And this is what I was explaining to you before also, that the prima facie or the interpretation of the prima facie word used in this UAPA is not very broad. It is narrowly interpreted. Why? Because the provisions are very stringent. You cannot go on granting bail, a regular bail. And the Supreme Court has also agreed that the court cannot analyze the evidence. It will only see the totality of the case. And if it finds that prima facie the accused is guilty, the court is not going to grant the bail. Then in the case of NIA versus Zahoor Ahmad Watali, this judgment was passed in 2020. The SC read the bail provisions strictly, holding that courts must not only be satisfied that a prima facie case can be made out to deny bail, and not consider the merit or the admissibility of the evidence. So what it is trying to say that in normal cases, what happens when you go to the court and ask for bail? The court will examine the merits of your case. The court will examine the evidence presented before it. So this happens in the normal case of bail, but in the UAPA it is not so. So the bail provisions have been made more stringent after the passing of this judgment. So the court is saying that no, if a person who has been arrested under the UAPA comes to you and asks bail, then you will not examine the merits of the case. You will not examine the evidences. You will just see that whether there is a prima facie case made out against the accused. If yes, you will not grant the bail. And that is why I have mentioned it before also, under UAPA, jail is the rule and bail is the exception, which is completely opposite to the normal criminal rule of bail. In normal criminal law, bail is a matter of right, but not under the UAPA, and this provision is very stringent in nature. Now let us analyze UAPA tribunal. So the central government has the authority to appoint a single member tribunal known as the Unlawful Activities Prevention Tribunal if and when required. So what was the need of the central government to have this tribunal? Because the court stated, the Supreme Court stated that you are not giving ordinary jurisdiction to the courts to examine the evidence, to present, to analyze the matter before it. And in fact, under UAPA, a person is directly arrested and detained for 180 days, which is not the case with ordinary criminal laws. For example, under CRPC, if you are arrested for committing a crime, you will have to be presented before a magistrate within 24 hours of your arrest. But under UAPA, you can directly be detained and arrested for 180 days. So the court intervened and asked the central government that what is the criteria on which you are declaring this person as an terrorist? What is the criteria that you are banning this organization? Explain it to us. We agree that this legislation is going to protect the sovereignty and integrity of India, but you cannot act in an arbitrary matter. And that is why the central government had to come up with this UAPA tribunal. The chairman of the tribunal shall be the judge of the High Court, and all proceedings before the tribunal are deemed to be judicial proceedings. The tribunal will conduct an inquiry, will analyze why the central government has taken the decision of banning an organization or declaring an individual as terrorist, and then the tribunal will come up with this decision, and the decision will be final in nature. So this was all about the UAPA tribunal. So with this, we come to a conclusion of our today's discussion. We have seen what is UAPA. We have also analyzed why the provisions are so strict in nature. We have also traced its origin. We have also seen the lacuna in the act, that the provisions are very strict in nature. The central government has sweeping powers over the provisions, and the UAPA tribunal is also there, and normal courts do not have the jurisdiction. Even in the case of bail, bail is not the right. It is an exception. In fact, you can be arrested and detained for 180 days straight. So if you ask me, ma'am, what is the way forward? Why is UAPA being criticized by the human rights organizations? Because of its low conviction rate. It has only a conviction rate of 2%. And it is often argued by the human rights organization that it is violative of the fundamental rights. It does not give you a fair hearing because there is lack of transparency. The tribunal also does not disclose the case fully because of the sensitivity of the matter. In fact, the central government presents the evidence in a sealed envelope to the tribunal to analyze. And the decisions are final. They cannot be questioned that why this thing has happened, or why this organization has been banned, or why this individual has been declared as terrorist. So UAPA does require a massive reform. Firstly, you need to remove the vagueness. Secondly, you need to give courts more power, normal Supreme Court more powers under this act. And thirdly, the provisions should not be misused in an arbitrary matter, as has been alleged by the opposition, that the government uses this UAPA to subdue the dissent going on in the public against the government and the government policies. So there is a need for reforms in the UAPA Act. Now let us analyze a practice question for your prelims examination. So the question is, consider the following statements. Your statement number 1 is, The act is applicable even if the offence is committed outside India. Your statement number 2 is the union and state government has power to designate an individual or an organization as a terrorist. Which of the following statements given above are correct? Your options are: option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. Kindly drop your answers in the comment box below. Now let us analyze a practice question for your mains examination. So the question is, Unlawful Activities Prevention Act UAPA is the India's main anti-terrorism legislation. But UAPA is being grossly misused, often with impunity. Discuss. So your approach can be, you will introduce, in the introduction you will write about what is UAPA, when is enacted, what was its origin. Then in the body you will write the key issues and the key provisions, that bail is strict, you can be arrested and detained without trial for 180 days, and then you will mention that the terrorist activities definition is very broad and vague. Then you will conclude that this provision has a low conviction rate, this legislation has a low conviction rate, and if it is often being misused and used in an arbitrary manner to oppose dissent. Then you can conclude that this legislation, although it is a need of the hour to prevent any harm to the national security, integrity and sovereignty of India, but it requires some reforms. So you can conclude your answer by stating all of the above points. I hope this session was insightful for you. If you have any feedback regarding the session, kindly drop it in the comment box below. If you found today's discussion helpful, kindly like the video and subscribe to our channel for more such updates. Thank you.